California landlords, you might need to add a big ticket item to your holiday shopping list this year. Stay tuned for details on a new law that kicks in January. Hi, I'm Brian Bean with Dream Big Property Management here in Riverside, California. Today, we're digging into a new law that requires most rental homes in California to come with a full set of basic appliances. AB 628, signed this month by Governor Newsom, takes effect on January 1st. And going forward, for all rental agreements signed, renewed, or extended, the following items must be supplied at the property. 1. A stove in good working order, capable of safely generating heat for cooking. And 2. A refrigerator in good working order, capable of safely storing food. Those items will now be considered essential, like heating, electricity, running water, and without them, the property will be considered uninhabitable. So what's the TLDR here? Well, if you're already providing these appliances in your rental, you just need to make sure that they remain in good working order. That means if they break, you fix it. But in Southern California, it's not unusual for a renter to have to lug around their own refrigerator. And in most cases, that will soon come to an end. As an Inland Empire investor, here's what you need to know going forward. AB 628 applies to any lease started, amended, or extended on or after January 1st, 2026. Existing leases that continue unchanged are not affected. But the moment an existing lease is renewed or changed in any way, the new rules apply. So what constitutes a change? Well, a formal lease extension, a rent increase, any change in the terms are obvious, but what about month-to-month rental agreements? The new law refers to agreements that are signed, renewed, or extended. When a tenant remains on a month-to-month after a lease expires and a landlord accepts rent, California law says the parties are presumed to have renewed on the new month-to-month terms. Though the new law doesn't specifically address this question, we're erring on the side of caution and treating it as if the new rules apply. What does good working order mean? Well, AB 628 also doesn't define that, but let's just assume that it means the stove provides enough heat to cook food and the refrigerator keeps your food cold or frozen, depending upon your needs. This law also requires that any recalled appliances be repaired or replaced within 30 days of being notified of the recall. If a rental property does not have these appliances in good working order, or if an existing appliance is subject to a recall, the property could be considered legally uninhabitable. What about current renters who have their own refrigerator? The new law applies to residents. It allows them to provide their own refrigerator and to continue to do so if they already provide their own. Starting January 1st, you'll just need a written opt-out agreement if they want to continue to use their own. And the renter can still request later that you provide a refrigerator with 30 days notice. Also, you cannot require a resident to provide their own refrigerator as a condition of renting the unit. But this allowance is nice for when residents want a newer or a specialized fridge. How about exemptions? These new requirements apply to many rental homes in California, but there are some exceptions, including permanent supportive housing, think assisted living, single room occupancy, like rooms for rent, residential hotels, and any facility with communal kitchens. Now let's talk about the penalties. This is an issue of legal habitability. A rental unit without a working stove and refrigerator will be considered legally uninhabitable, the same as a unit without heat or running water. If that were the case, residents could withhold rent, they could start repair and deduct procedures, they could use it as a defense against an eviction, or they could potentially pursue litigation against you for habitability violations. And you not only have to provide those appliances, but you also have to maintain them. A stove element burns out, refrigerator compressor dies, you must address it promptly. If a refrigerator is under recall, you must arrange for a repair or replacement immediately. No more without warranty stipulations in your lease. With all that in mind, here are your next steps. 1, take inventory. Go through every rental property you own right now and document the condition and age of your stoves and refrigerators. Take photos, note the make, model, serial numbers, approximate age. Budget now for replacement to be ready when it fails. 2, check now for recalls. Go to cpsc.gov. Search every appliance model. If you discover an open recall, get the repair ordered as soon as possible to beat the crowd. 3, update your rental agreements. Work with your attorney or property management company to make sure that the language in your lease is updated for 2026. 4, do not underestimate the cost. When government gets involved, it tends to affect market prices. Just look at the cost of health insurance and college tuition, for example. Those seasonal appliance sales you're used to, those could go away. You might want to make your purchases sooner rather than later. And then budget for the future. Refrigerators typically last 10 to 12 years. Stoves can go 15 to 20 years. 5, plan ahead. Do you have leases renewing in early 2026? If the appliances are marginal, or if they belong to your resident, you may need to replace them. Look into buying now in preparation. And for properties that are vacant now, probably best to install those units before leasing them, even if the move-ins happen this year. Lastly, protect yourself. This law, like most, is gray and leaves many questions unanswered. For example, it doesn't define good working order. It doesn't specify refrigerator size or number of burners required for the stove. It doesn't define what a stove is, whether it's a stovetop or did they really mean a range, which would include an oven. These questions may eventually be clarified by courts or through habitability disputes. So here's my advice. Don't be the test case. Err on the side of caution. Provide normal standard appliances that match the property. If it's a 5-bedroom home, appliances will probably be larger than those in a 2-bedroom ADU. Not luxury. You don't need a Sub-Zero refrigerator or a Viking range, but provide what a reasonable person would expect in that specific property. Because if a resident files a habitability complaint claiming your compact refrigerator or 2-burner cooktop doesn't meet the standard, is that really worth fighting about? Now, why is this important? Renters are a growing population in California, and the cost to lease a home here continues to climb. Basic appliances that allow a person to have and prepare food is not a luxury in permanent housing. It's a baseline standard that we all expect. From state to state, city to city, even neighborhood to neighborhood, there is no standard when it comes to what appliances you can expect to find in a rental home. And that makes it very difficult for people when they move. The question is, should that matter? Should renters, who, by the way, can be told to pick up and move on with as little as 30 days notice, be expected to pack up among their belongings large appliances in order to relocate? And until now, the answer has been yes, but no more. And rightfully so. Even though these new rules will be short-term hardship for some rental owners, in the bigger picture, this will be good for everyone long-term. Our residents will find it easier and less expensive to move, and our investors will have more candidates for their vacancies, not just those who have refrigerators in tow. Owning rental properties is the surefire way to build wealth in this country. It's the one thing that allows a regular person to work hard, be disciplined, position themselves to buy real estate, and then go from financial zero to hero. Providing what that most people consider basic necessities will help fill vacancies quickly, keep them longer, and increase the financial returns over time for the owners. And you know what else? When you provide a nice home for a renter, it just feels better. And if you can build a retirement for yourself at the same time, that's a win-win. If you have questions about the new appliance rules or any other of the dozen or so new rental home laws in California, call me directly, 951-314-5402. Happy to share. You can also find valuable information on our website, dreambigpm.com. Also, if you found the information you heard here today useful, please do us a favor, like and subscribe so that we can help others just like you. Don't be accidental about your future. Be intentional to your success.